Joey here as the Critical Missourian, where I talk about everyday life, about Missouri and beyond. Okay, people. Something that just caught to my attention is that a new bill has been floating in the General Assembly to Missouri, to limit the Missouri Supreme Courts and making any challenges to a proposed bill in the General Assembly, which I don't know if that's really a good idea. I mean, the purpose of a judicial review is to make sure that each law is constitutional or not. So if we take the courts out of this situation, then it may prove to be a problem. Also, there's a big question of whether this proposal is coming right at the time that there is a anti-abortion bill that's being floated around too, and there's concerns that this new bill to limit the judicial power is being used to stop the state Supreme Court from reviewing or limiting anything to do with the anti-abortion bill. So it's throwing a lot of questions there. According to the language of this new bill, it will give the Secretary of State the ability to make changes to the bill instead of the court system, which that is a whole new can of worms in itself. That means one person can do a lot of things, like resubmit the proposals and not good terms, or delay any challenges to any bill. I mean, it's really on shaky ground right now, so I'm really calling out a lot of questions on this. I mean, and also, I'm just seeing that there's also changes that's proposed in this bill, where any preliminary injunctions that are issued by the court can be challenged by the Attorney General or appealed. That limit the state from enforcing any statutes or the Constitution or the state constitution. So I really don't know. I mean, there's reasons why preliminary injunctions are made, especially if there's any objections, whether something questionable has arisen, there's anything during the judicial process that that needs further review, or a process or an action is put a stop to until the judges have reviewed the case and say whether it's constitutional, unconstitutional, whether it's with the law or against the law. That was the point of why we have injunctions. But now, according to the language in this new bill, anything that prevents the state from enforcing any statutes or anything is now can be challenged by the Attorney General. I don't know if that's and that's getting into a murky water right there. Also, I just have many concerns. Whether or not, I can understand our judges need more accountability and more limits to their power. But it depends on which powers that the judicial system has that needs limiting, review, or whatever. It's got to be done tactfully and within certain reasons. Just doing willy-nilly, just to make changes to the judicial system, just to fit your narrative, is not really a good thing. I have concerns about that. Having the judges to write laws is one thing. They're there just to review a law and make sure that's constitutional or not, and make sure it's within the letter of the law, and send the bill back to the legislators with amendments, suggestions for changes, whatever. That's under the current law that we have in the state, is that they do have the ability to intervene on any bills that can be considered that needs changing or whatever. They can always do that now, but that's concerning that now it's limited. It's going to limit the court to even do that, to review or make changes to any new statutes or constitutional amendments or anything. That's the I do agree that this is the this is the power of the court. They're supposed to be making sure everything is within the law. But I do agree that the courts do need the power to write laws. Trying to write laws for the state. I do understand that needs to be written. But do not take out the powers for the court to review a bill that they feel is unconstitutional or whatever. Do not interfere with that. They have to be, that's the power of the judicial system, is to make sure that everything is following whatever the law is, and to make suggestive changes. But if you put that in the hands of one person, like I'm seeing that this is, it's, I mean, you give more power to one person to rewrite any proposed laws, or before even the courts have any say in the matter. This is what it's saying, is it's given this one person, Secretary of State, to rewrite any proposed bills before even the court has a chance to review that. And like I said, we really need to rethink how we're doing this. One person should not have too much power in one hand. I mean, I know that's what the governor's job is to do, but one person to sit and make changes to any bills before a court gets a chance to overlook it raises a lot of questions. And like I said, the one thing that does point into question is the timing. The timing does not seem, just kind of stinks. Kind of stinks that they're trying to make this new bill right at the time that there's another bill that was supposed to limit the anti-abortion legislations or bills or whatever. Then that's kind of fishy. So I don't know. I'm just presenting the information as I see it, and my opinions, which take with a grain of salt. You'll have to formulate your own. But so many questions have kind of flagged with this, and I'm just going to put it out there for everyone to really think about on your own. So, anyhow, like I said, our state's getting a little wacky. So, anyhow, I hope you liked the video, and this is the Critical Missourians signing out, and I hope I see you on the next video.